while people are entering. Today, the webinar, the title is Protecting the Ocean, Legal Tools, Gaps, and the Fight Against Marine Pollution. This is a particularly meaningful conversation for us at the LTC's Foundation because it connects the dots between our ocean cleanup work and the legal framework that either support or hinder that action. Today, we will dive into the world of environmental law, pollution accountability, and even the fascinating and fast-evolving field of ocean rights. This session also picks up where we left off just a few days ago at the Our Ocean Conference in Korea, where LTCs hosted a side event on the ownership of marine litter. In that conversation, we explore the legal gray area surrounding who is responsible for pollution and who should be held accountable. Today, we are going to a step further, hopefully, going from ownership to action and from policy gaps to legal innovation. We have 3 incredible speakers lined up, each bringing a unique perspective and a set of stories and cases that will hopefully make sense and make this legal concept more tangible and accessible for everyone. So yes, I see some people writing on the chat. Hello to everyone. Also, if you want to write us where you are connecting from and who you are, also it would be nice to know who is online. So let me begin by introducing our first speaker, Veronika Mikos, the director of LTCs. Veronika is a bit low in her voice, but I think she will manage. She's an economist with over 2 decades of experience, and she has been the head of the LTC's Foundation since its founding, leading the organization for the past decade. Under her guidance, LTCs has emerged as a leading organization in combating marine litter, particularly lost fishing gear, through prevention, cleanup, and education. She has also cultivated strategic partnership with industry leaders and stakeholders, facilitating cleanups and the recycling and repurposing of recovered fish net into sustainable products. Today, Veronika will walk us through some of the major challenges LTCs has faced in the field, including the most recent abandoned fish farms, the so-called ghost farms. She will talk about that, and the legal obstacles encountered in addressing them. So I'm going to go with the first question. Can you tell us what ghost farms are, first of all, because it's a strange term, and what kind of legal and regulatory barriers you encounter during the cleanup?
Thank you, Samara, for the introduction, and hello, everyone. Hopefully my voice will not take away from the quality of this webinar. It's a very exciting topic for us. LTCs has been taking action on marine litter and more specifically ghost nets in the last 12 years. And relatively recently, 4 years ago, we discovered a phenomenon which we started to call ghost farms. Those abandoned facilities where industrial scale of pollution is happening. Based on the term ghost nets, we started to call these facilities ghost farms. There are 2 major differences compared to marine litter in general, what these so-called ghost farms have. One of the big differences is that the owner is known, always. So the company behind or the individual in charge of that company who owns this waste, which is spreading hundreds of meters of coastline, often kilometers of coastline. In a case of any other marine litter, if you do a beach cleanup or swim by the sea and you pick up a piece of litter, you can check the expiry date, you can check the origin of the country, you can play a little bit of Sherlock Holmes trying to figure out where is it coming from, but you will never know who is responsible for that. In case of ghost farms, with a little bit of research, you can figure that out very quickly. So that's one major difference compared to marine litter in general. The other difference is the scale of the pollution, like I already mentioned. We are talking about vast amount of waste, all kinds of plastic, styrofoam, nets, hundreds of tons often at a site, which is very, very complicated to recover. So today we focus more specifically on legal barriers. Before we jump into that, just want to show you two photos because those say more than 1,000 words. This is how an abandoned fish farm looks like before we arrive and after. So to give you a little bit of idea about the scale, here you can see a couple of photos not being photoshopped, but physically by hands. Enthusiastic volunteer divers from our partner organization Ghost Diving and many, many other stakeholders. Together we clean up areas like this. And in terms of efficiency, these are possibly one of the biggest cleanups in the world in terms of amount of waste collected in certain amount of time. And here you can see the summary of the last 4 projects we did, ended up with 270 tons of waste being collected in 3 different locations in Greece. Recently, we launched a documentary examining more deeply this topic. So you can find it online on YouTube and you can learn more about it. So in terms of legal barriers, what is really striking about these cases is that it doesn't happen like we find a site like this, we go there and organize a cleanup. First, we find a site like this based on reports of locals, various lines of information, and then we organize surveys at this site, both on the surface and underwater. When we identify the size of the problem, then starts a very, very long process, legal, bureaucratic, with authorities, with government bodies, trying to understand the status of this site. Because often it looks indeed abandoned and we take it for granted that it's waste. But on paper, 99% of the time, these sites we have found are active. They hold a valid license and they are an operational fish farm. And that's when it starts our labyrinth of work with law firms and supporters and various project managers who are trying to untie this knot of Gordius to find a way to understand how is it possible that a seemingly abandoned site looking like a landfill can be called as an operational fish farm. So this is legal barrier number 1, not having a clear status of the fish farm. Reality not reflecting paper. And just the second one quickly to mention is the roles and responsibilities. So the moment we start to contact the authorities, there are various departments, various offices trying to point out to each other, not even being sure who is responsible to tackle this topic. Local municipalities are often not in charge. They are not the ones who gave permit to this fish farm. We also know cases where the whole island community voted against it, but at higher level, at the provincial or national level, that has been rejected. And fish farms do get a permit, not from local municipalities, but from other government bodies. And then once it's abandoned, then typically everyone is pointing out to each other who they believe should clean it up, while the owner is not available or not taking his or her responsibility. So in a nutshell, this is a legal barrier number 1 and 2 with the ghost farms.
Thank you. And so do you think it's this legal uncertainty that is around the process and the procedures that create this complicated action in case of an NGO like LTCs who tries to clean it up?
First of all, we never act alone and we don't decide on our own. According to existing law, it's always the responsibility of the owner to clean it up. In Europe, we have something called the polluter pays principle. This is the heart of European environmental policy, and it's a very simple idea behind. the one who is covering the environmental damage is supposed to cover the costs. This does not happen in many cases. Then would come step number 2, that the authorities step in and they take action. If the owner is not cleaning it up, the authorities will and send an invoice to the owner. Luckily, this is happening in many European countries, not in Greece, for example, where we operate more typically on the ghost farms. And that's where we come in. If we mobilize local communities, a wide range of stakeholders, recycling companies, sponsors, and we bring together an enthusiastic and committed group of people, then we can step in and act based on an authorization from the government. So basically helping them to solve an issue for which they do not have money, time, capacity, knowledge. And on their behalf, we clean it up. But we do not act on our own, and we don't act alone. It's one of the power points of the Ghost Farm project is the wide range of partnership, which is making it happen, and making it happen in order to show that there is a way. If there is a will, there is a way.
Oh, yes, I was muted. And what kind of legal and financial administrative mechanism, let's put everything together, what kind of options would make a difference for organization like LTCs?
Staying at example of Greece and these various fish farms we cleaned up in the last 4 years, what would be really important from a financial point of view, if there would be a mandatory insurance mechanism in place. Currently, there is none. And although there's been an effort in 2010, the law envisioned one, but it didn't get through. When a fish farm gets a permit to operate, then there are various studies made, environmental impact assessment, before the permit is granted, or parallel with that, there should be a mandatory insurance mechanism in place. In case of bankruptcy, in case of whatever happens, there should be an amount of money set aside to cover potential cleanups in case the bankrupted company or whatever reason is not able to do it. Same way as if you go and rent a house or an apartment, you also put a 1 or 2 months rent aside in case you cause any damage, right? Here, the companies do not own the sea, they lease it. And in Greece, it's a minimum of 20 years of lease. In those 20 years, there is also no regular monitoring process. So this could be another huge benefit for the society next to the mandatory insurance mechanism if a regular monitoring system would be in place, because now if a company gets a license for 20 years and goes bankrupt after 10 years and starts polluting the area and disappears, but still holds a license for another 10 years to come, then what can we do? We go to the authorities, we walk a long and complicated path. The authorities start to investigate, maybe they succeed, maybe they don't, but all this would be not necessary if regularly on their own, they would just check the status of these farms instead of conservationists, local communities, mayor needed to spend time and money and effort on asking the authorities of please check the status of the companies you gave license to. Extended producers' responsibility being in place or the lack of it is another element. And there would be a couple of other smaller ones, but I don't want to take too much time. Maybe we can discuss it later as well.
Yes, maybe we will come up in the question. So thank you, Veronika. So we started with a very specific case, which is what sparkled our curiosity about looking into legal aspects, because we thought it was really incredible that even in a case like this, where ownership is very clear, still the legal barriers were so high to the cleanup. So we started with the case with Veronika. Now we are expanding a little bit more into something else. Maybe let's call it marine pollution. Next, I'm very happy to introduce Rogier Hörchner. I don't know if I did it right. An environmental lawyer known for his sharp activist approach and decades of experience reporting representing environmental NGOs, waste companies, and others. Rogier is the founder of Hörchner Advocaten. He will tell it right. His firm puts justice and environment at the heart of legal work. We invited him because he has taken on cases involving pollution, environmental damage, and government accountability, often when others wouldn't. Today, Rogier will share insight from real legal battles, including a recent case in the Netherlands involving plastic noodle spills. This is especially timely as new European legislation has been passed addressing this issue. So we start from that, Rogier. Can you talk us a little bit more about your work?
Yes, I'm Rogier Hörchner. We call it Hörchner here. I have a law office in Breda in the south of the Netherlands. And our clients are companies, civilians, but also many environmental organizations, very small, some very big, some others. For example, we help Greenpeace for almost 20 years in many cases, but also other new environmental organizations like Plastic Soup Foundation or Fair Resource Foundation. And in our practice, we have a lot of experience on several topics. And to make it clear, in legal view, you can divide it in criminal law, administrative law, and civil law. And to begin with the criminal law, because then I can be very short, there is a lot of environmental regulations about everything you can imagine. But what we see in the Netherlands, though, is that the Dutch Public Prosecution Office doesn't make many sense out of it. When we file a case, I think that 1 out of 8 cases was successful, and they brought it to court. And in all other cases, when it was a clear infringement of any law, the public prosecutor had some kind of argument that they say, for example, that the administrative law is prevailing or something else. So the criminal law doesn't work very well in the Netherlands, except for very big cases against Chemours, for example, with a lot of PFAS scandals. Then maybe they will make a case out of it. In our practice, we have a lot of administrative procedures. They start with a law enforcement request. That's quite well regulated in the Netherlands, because here the Council of State has decided about 25 years ago that there is an administrative obligation principle to enforce the law. So when you file a request at the local government or the central government, then you can make probable that there is an infringement of any administrative law, they have to make a case out of it. They have to search for things. So that means that we file regularly a lot of administrative cases to the Dutch authorities and ask them to undertake action. That can be successful, as we have seen in the Greenpeace case we have done for the European timber regulation, where Greenpeace saw that about 11 companies were infringing the duty of care and the due diligence system that has been laid down in the European regulation. And that was quite successful, but what you see there, and everybody will recognize it, I think, is that it takes a very long breath to have such a case. Before you know it, you're 7 years further. So the long breath, the money, of course, you have to hire a lawyer, but also you have to have your own employees or volunteers, etc. That all costs a lot of money. And what also is one of the difficult things is your information position. There are nice laws to disclose all kind of information. And the terms here in the Netherlands are 4 weeks. So when you file a disclosure request, you should get your information within 4 weeks. But in the Greenpeace case, I got the information, I think, after 3 years. I had to go to court for it, etc. And that's quite difficult. Another thing that could also be difficult is that when there are nice rules, for example, there are many rules on packaging, also cases we have done. There's a packaging regulation from 1994, and there has been written in that regulation, for example, that packages should be as light as possible, and other essential requirements are written there. But then it's for about 25 years a dead letter, and when I have filed for the Fair Resource Foundation a lot of law enforcement requests, then the government, they started some action, but after a year they stopped it because they said, yes, the articles are not clear enough, they are too vague. And that's the same as what we have also seen a bit in the Greenpeace case. The politicians are very happy with themselves because they define a duty of care or a due diligence system or an essential requirement that every package should be as light as possible. But in the end, they don't know for sure what does it mean as light as possible. And when we use recycled materials, can it be a bit heavier or not? So that's one thing that we also see many times, that even when we are successful, there's a big discussion about the definitions. So that's also something that you have to keep in mind when you start lobbying, for example, for better environmental rules, that politicians are many times very happy when they write something down as from, yes, now the world will become better. But then when I'm a lawyer and I have to use those tools, the tools aren't sharp enough in many times. I can give you two examples of cases we did about the nurdles. That's indeed very interesting. There's now, I think it's an European directive, I'm not sure, or a regulation that's pending. It's still in concept, if I'm sure, that Europe will thinking about making rules to fight the plastic nurdles and prevent the loss of them, the industrial loss. What we did in the meantime was file a law enforcement request at the Dutch authorities in Rotterdam against a chemical or facility making those nurdles and spilling them. And what they did in the end was looking there, finding all those kind of nurdles, and they made a decision that the facility had to clean it up and prevent their spills for the next years, and if they didn't, then they would get a penalty. That was quite a clear case. A more difficult case is what we have not done yet, but we hope to do, is the cross-border pollution from Belgium to the Netherlands. In the Netherlands, you have the Natura 2000 area of the Westerschelde, Saftingen, and next to that is the quite polluted harbor of Antwerp. There are about 25 facilities there recycling plastic, but most of all other facilities making plastic, and they spill quite a lot. They spill it with the transport, they spill it on their territory, etc. And what we have done, we have made a few years ago a legal opinion, and in that legal opinion we have described all the ways we could use the administrative way. We could go to the Belgian authorities, maybe we could go to the Dutch authorities, and what we see here is that I think that there is enough there are enough legal rules to fight such a case. We can use the European Habitats Directive, for example. You could use the Water Framework Directive, for example. But the question is, who do you want to fight? Do you want to fight the Belgian companies? Do you want to fight the Belgian government? Do you want to fight the Dutch government? And then, yeah, you have the administrative law you can use, but you can also use the civil law. That's something that has been developed the last 10 years, I think. Maybe you know the Agenda case. It was quite new in Europe. That's an NGO starting with a case against the Dutch government because not fighting climate change enough. And before it, I thought I've read their statements and I gave it about 10% chance. I was not convinced about their case. But what you saw then was they started a civil procedure. They won the procedure, and now it has started an own life. And after that, you saw Milieudefensie cases. You saw Greenpeace cases about nitrogen, for example. And yeah, they're piling up all those kind of cases. So one of our conclusions was also that it could be very interesting new jurisprudence that we could file a case against the Dutch state, because the Dutch state has many instruments to claim things from the Belgian state. So that's something we're working on and looking forward to it.
Super fascinating. But you put a lot of different cases. So if we want to try to wrap up, and you already mentioned something in each case, but if we want to try to give a summary, what do you think are the limitations of current tools in case of criminal laws? What do you think is missing? What do you think is not working in this moment? Is it coordination between the different levels?
The criminal law has mostly to do with the fact that the Dutch prosecutor is not willing to make a case out of it. I think that there's enough to make a case out of it. And what I've seen also, but because I've also done some research before this webinar about those spills of nurdles in Antwerp. Those spills are known for about 10 years, and what you see is that there has been done scientific research. Politicians have discussed it. They have discussed it with the Belgian authorities, but now it's I don't hear anything from it in the last 3 years. So that's also one thing. You have to put many efforts in it. You have to keep it on the agenda. And yeah, it also costs time, money, etc.
Yeah. And what legal reforms would make your life easier in this case?
Now, I don't need many new ones, I think, but we're still waiting for the European directive against the loss of pellets. I'm looking forward to it. I saw that it has been discussed a few months ago again, but I don't know whether maybe we could make a case out of it already. There are many rules, Stockholm Declaration, Rio Declaration, and many other rules that it's, to say it simple, it's forbidden to pollute or to pollute the territory of your neighbor, etc. So those kind of rules and principles are already there. I think that the biggest point is that we have to make action out of it. And one thing that's also happening, I think it's quite new in the REACH rules, that the plastic facilities now get a duty of care. It starts in 2026, I think, that they have to report about their emissions of plastic noodles. But it's also quite fake, I think. That, yeah, most important is to undertake action in these cases.
So is when you mean action, you mean also political, I guess, willingness to make this work, and also enforcement. What do you think is the role of these two things, enforcement and political action, really?
Political action stays very important because they make the music, let's say it like that. They make happen what is being talked about. So that's also a small part of my job, that we also do some lobby work. But what you see there is that politicians are all very busy. They all have 100 cases to discuss. They don't have the information. So if you can give the right information to usually left-wing politicians, but it could also be right-wing politicians, of course. That lobby is very important. There is a task for the NGOs to keep on giving the information to the politicians, because otherwise they have other things to do. Yeah, and that's it. And the second question was
Enforcement. But you already speak to that actually you don't need anything much new stuff, but you need these things to take action, really.
Yeah. Maybe one thing to think about is that if there will become new rules, European rules, and then it could be nice if there will be written specifically something about the role of NGOs. There are some directives where you can read it, but it's the information position and the necessity to have an entrance at a court is also very important, and that's not in all countries very clear. In the Netherlands, it's quite well organized, but I've heard, maybe Michel can say something about it, that in Germany or other countries, they don't have the same obligation principle to enforce the law as we have here. They have to start for civil procedures instead of administrative procedures. When there will become new laws, European laws, then there should be written in it what the role of the NGOs will be.
Very interesting. So I'm going to introduce Michel. And then if you want to directly answer to Rogier. But so Michel is the legal counsel with Ocean Vision Legal, the first law firm worldwide and entirely specialized in marine protection. Michelle created, and she's the leading expert in the movement towards ocean rights, an ecocentric framework to protect and restore ocean health. She has drafted the rights of nature laws and policies worldwide, including the US, Panama, the Pacific, the Philippines, and the international law and institution. Michelle is a steering committee member of the UNOD, coordinating office on connecting people and ocean. In 2018, she was named one of the 15 youth ocean leaders by Sustainable Ocean Alliance at the World Ocean Summit, and in 2017, 217 was accepted as a member of the IUCN World Commission on Environmental Law. Michelle will help us shift our lens on even more on the international level, and show us how legal innovation is transforming how we protect the ocean with ocean rights. Michelle, if you want to introduce a little bit your work and directly answer to Rogier if you have any information about what he was telling us about the presence of the NGOs.
Thank you so much. I have some slides to walk through, and actually a part of that is is somewhat responding to this issue of who has standing to represent or, go to court for nature. So my work, as you introduced, is a little more high level international governance, but also really looking into the underlying norms and ethics that guide international law. So at Ocean Vision Legal, we find that there are a few important legal levers that are really underutilized when it comes to marine protection and addressing marine pollution. First being enforcement, just like we already talked about, holding states accountable for these existing legal obligations that are under international or national law. And then what I will be speaking to more specifically is shifting the foundational values and ethics that influence how and to what extent law is implemented and enforced through ocean rights. And I need to hide that. There we go. So in looking at the state of global ocean governance, we're seeing, of course, it's a very complex and fragmented system. We have hundreds of institutions, frameworks, and bodies that oversee different aspects of how we use and protect the ocean. But at the center of this system is the United Nations Convention on the Law of the Sea, or UNCLOS, often called the Constitution of the Ocean. And the UNCLOS has many provisions that apply to state obligations in the context of marine pollution. They include the very important obligation to protect and preserve the marine environment, and the obligation to take all measures necessary to prevent and control, reduce pollution of the marine environment from any source. This has been found to mean that states are required to adopt and enforce their national legislation to prevent such pollution, and in particular to adopt mitigation measures. And most recently, in the Commission of Small Island States advisory opinion to the International Tribunal, the Law of the Sea, pollution was actually defined to mean and include greenhouse gas emissions as well. In December, the Intergovernmental Negotiating Committee on the Global Plastics Treaty did not reach an agreement after 2 years of negotiation. And there are many reasons for this. Delegates, negotiators couldn't reach a consensus around the treaty's objectives, the level and ambition that was sought, particularly when it came to the measures that states should implement and the targets for the reduction of overall plastic production. So we have these obligations that exist that bind states to take active measures to address marine pollution, yet states are not agreeing on these obligations or fulfilling them. So this is then a point of reflection to ask ourselves why. Why are these obligations not being enforced? Are they achievable? And in doing so, and this is what I find really intriguing and one of the most important exercises to do, we can start to see that our responses to environmental problems are what can be called single loop learning. So we're addressing the symptoms rather than the root causes. And in our opinion, achieving the protection and preservation of the marine environment, addressing marine pollution in particular, is a systemic issue. So this is what we need to start looking at, is double loop learning, which means questioning, challenging, and changing the very values, goals, practices, and institutions that created the conditions to arise in the first place. And environmental law can largely be characterized as having very anthropocentric or human-centered colonial values and perspectives, where we prioritize human benefit and economic growth over the protection of the environment, even in laws designed to do the opposite. So even here in the US, we have amazing environmental law. If you just look at the texts themselves, not how they're being implemented or enforced. For example, the Clean Water Act, it sets water quality standards and limits for the maximum amount of a pollutant that can enter a water body. But these standards, they're defined by human health standards, not what the river or the water body ecosystem or its species need to be healthy. So that's what we're talking about when we refer to anthropocentric or human-centered worldviews and perspectives that underlie our environmental laws. So we're starting to see that they're functioning under this flawed narrative and worldview where humanity is separate from nature, with nature as a resource of property here for benefit and utility for human society. And this is where my work and focus on rights of nature and ocean rights comes into the equation as a potential solution. Ocean rights is the ethical, moral, and legal recognition of the ocean as a dynamic, autonomous, and living entity with inherent rights and intrinsic value. I created the concept of ocean rights in 2017, building from the growing rights of nature movement, which now has over 400 laws, policies, judicial decisions, and initiatives in almost 40 countries. And 15% of these are specific to, or they have explicit mention or a scope for marine ecosystems and species. And I want to note that the framings that this concept embodies have existed long before I coined the framework. Many indigenous and oceanic communities have long understood and treated the ocean as a relative, an ancestor, a kin, who we are in relationship to and we have responsibilities toward. And that understanding, their customs, customary law, balances the needs of people with the capacity of the ocean. And this is done without a Western framework of rights. But ocean rights really stands at this convergence of indigenous science and worldviews and Western legal systems and science, and can help shift how our relationship with the ocean from one of exploitation and separateness to one of partnership and reciprocal responsibilities. Now, it doesn't do that with just the recognition of rights. In order to be effective, the recognition of rights must be accompanied by the development of implementation and enforcement mechanisms, just as with human rights. So we can look at what principles and standards are being put into these laws, such as the principle of ecological development, in dubio pro natura, which means when in doubt, err on the side of nature. We are seeing new regulatory and institutional structures be put into practice that require bipartisan participation in decision-making, or guardianship structures, where representatives from the community and the government are required to represent the ecosystems or nature's interests in decision-making affecting its health. And we're seeing enforcement mechanisms such as civil criminal penalties, such as ecocide, which is considered the other side of the coin of rights of nature, and legal standing. And this is, legal standings is actually where a lot of the rights of nature are moved from Christopher Stone back in the 1970s when he wrote about should trees have standing. It was in response to a case here in the US where the Sierra Club could not bring the case because the court did not determine that they could have legal standing to sue on behalf of the environment. So here we have hurdles like being able to show that the harm to the environment specifically affects your life or injury to yourself, your property, your community, and that's how you have the authority to bring a suit. And so, for example, in Ecuador, with their rights of nature constitutional amendment, any person, any government, any community can bring suit on behalf of nature if they think nature's rights are being violated. So that starts to really, change who has a voice for nature and bringing nature's interests into the equation. And it sort of serves as a form of checks and balances in a way, where in really traditional decision-making processes, we don't consider the ocean's interests, what does the ocean need to be healthy? But now we're required to, because the ocean has standing to be included in decision-making and disputes affecting its health. And I want to just highlight how this could apply, within the context of marine pollution, more specifically, using some examples. And to do that, I want to note that this is a new and growing movement. So Ecuador is the first and only country to recognize rights of nature in their constitution. They did this in 2008. So it's fairly new, less than 20 years. And if we think about human rights law, that's still being implemented and enforced. There are still gaps and challenges in that. But I do want to, just show what we're learning, for example, from Ecuador, because they have been one of the few places to actually implement and enforce these laws, that we can really understand robustly and specifically what does this mean in practice, and how could this apply to different contexts, different issues like marine pollution. And so one example of a rights of nature law that has emerged is in Panama. They not only have a national rights of nature law, but they recognize that sea turtles are subject of rights, and that sea turtles then have a right to a healthy environment free from pollution. So what does this mean, in practice? Ecuador has determined that animals with migratory behavior have a right to have their migration routes and habitats respected and protected. So in practice, fulfilling this right is found to require precautionary and restrictive measures to remove barriers to migration, to ensure this right isn't violated. So we could see this applying, for example, in needing to phase out the gear like drift nets or long lines that are unintentionally catching marine species, not only when they're being used, but as ghost fishing gear. And this would be an enforceable duty. Another example we have that hasn't risen to the level of national law, it's local non-binding proclamations, but to address the issue that is happening with the southern resident orcas in the Pacific Northwest, who are critically endangered, with only approximately 70 individuals left in their population, their distinct population. And, the main threats to their survival are seen as the lack of prey and fertility issues. And these fertility issues have been linked to, for example, the bioaccumulation of toxins in their fatty blubber and their tissue. So we can start to see how, for example, recognizing their right to a healthy environment, the government would then have a legal obligation to regulate and limit land-based pollution and contamination into marine ecosystems. And I want to highlight, that's why I say may, is because this is still a growing movement where, this is looking at how these examples would then apply in these different contexts. But for me, that offers a lot of hope and really gets me excited about the possibilities for the framework. So just in closing, I'm not only excited about ocean rights in the context of rights in nature, but global ocean governance and what are the possibilities there, and really creating a new ethical norm for ocean governance. It can really serve as a tool to address, like I said, those foundational values and norms that are influencing policy and economic activity. And while there's growing support for ocean protection and marine pollution, it can start to really change, I think, this unbalanced relationship where economic considerations are taking precedence over conservation, and start to balance the, marine interests with human interests in the decision-making processes. And the great thing is this is starting to really emerge internationally as well. We're seeing new agreements, declarations, and reports that are saying we need to evolve our current approach to environmental law and governance. So the UN Sustainable Development Goal 14 platform, they actually note it on that page that in order to maintain the quality of life the ocean provides to humankind, a change is required in how we view and manage the ocean. The Pact for the Future notes that a fundamental shift in our approach is required. And even the most recent Kunming-Montreal Global Biodiversity Framework that was agreed in 2020 from the Convention on Biological Diversity became the first international treaty to include rights of nature, noting that rights of nature for those countries who recognize them is an enabling condition for the effective implementation of the agreement and therefore the protection of biological diversity. So there's a lot of, things happening, growing every day, it seems like, in this movement. It's really starting to take off, but there's a lot of, you know, hope and excitement around, I think, how this can really help all the issues we care about. And even though it's so different in many ways, you know, even on this conversation today, we have so many disparate perspectives and focus areas. But what I am really seeing, especially with ocean rights, is all the different groups can resonate and feel like they can be a part of the movement, or that this framework can help the issues that they care about or that they're working on. So with that, I'll stop sharing.
Yes, I think so. Now I want to leave some space for questions while you there are some already in the question and answer. Let me check. Oh, yes, there are some already. So I'm going to start from here. And Isa, if you see any chat, any in the chat that I'm missing, please let me know. So there is one. What transnational, commercial, or private legal convention are developing that may provide the further forms of direct enforcement? Guess this could be anyone who wants, Rogier or Michelle. Should I read it again?
I'm not sure about purely commercial or private. You know, I mentioned the intergovernmental negotiations for the plastics treaty, but that you know is largely state focused and led.
Yeah. Also, this reminds me that I've seen that you have a webinar coming on the plastic treaty, right, Michelle?
Oh, yes.
Anna. So I think
Anna
that's an interesting point.
Yeah.
For those who are interested in plastic treaty. So if you want, Melinda, I think if you want to write us a little bit more about the question, if we understand it right, I'm going to go to the other one. Meanwhile, is there any legal instrument in some countries where offenders of ghost fishing pollution can be punished? So I think Michelle, you gave an example of not of this exactly, but of first legislation that could help. Veronika, Rogier.
The question is, how do you identify the offender? So in case of ghost farms, we can. In case of ghost nets floating general around the seas and oceans, we can't. And here comes in, I think, the power of this group here and the community to take a showcase, at least those where the owner is known. And one interesting piece of information came out last year, I will include here in the chat, from the European Parliament, where they intended to become the first international body to criminalize the most serious cases of environmental damage, which are comparable to ecocide. Well, I believe the ghost farms easily fall in this category, and also the cases Rogier brought up. Now the question remains what it means in practice. What are the implications and the implementations by the EU member states? That's the question what remains as always. But the intention is good, the start is good, and now putting it in practice would be even better.
I checked the chat. I don't see any other question that I missed, but please write us. I do have one question because what Michelle told us energized me very much, but I do have some questions about what is happening, especially recently, because I have a sense that since the Paris Agreement, we have in a way built an international framework for environmental and ocean protection that was based on voluntary commitments and on the principle that change would come from bottom up, and this approach was justified for the belief that international decision could not bind national legal systems. But today we see a kind of a shift in several regions of national decision that are reinterpreting, overriding, and most of these are not in favor of the environment. So what do you make of this moment? Are we seeing a weakening of the international legal framework, or are we seeing an evolution? Do you see opportunity, risk in this occasion, especially for ocean protection? This is open to everyone who wants to answer.
I think that we all know that we are now in quite dark times with the Trump guys and all other idiots that are there. But I think that in the long term, the legal frameworks we have, and the human rights framework, and maybe also the Declaration for Ocean Rights, if it will become real, that they will last longer than what we see now in politics.
Michelle?
Yeah, I mean, I guess I just add on it. I think we are seeing an evolution. We did introduce a universal, the initiative towards a universal declaration of ocean rights in 2022. And it's been amazing seeing who's come on. Cabo Verde publicly called and is supporting this initiative. With the support of Monaco, they introduced language to the UN. We received support at the summit in September 2023 from Volvo Cars, World Bank, Sylvia Earle, Panama. So it's that to me shows that we're seeing an evolution and folks are ready for it. They're eager. And like I said, I think, it gives me a lot of hope and to see that we are branching beyond this business as usual, not just saying it anymore, and really we're looking at, okay, so what does that mean though, to branch away from business as usual? It means doing something different.
I see two new questions. I'm not sure if you see them. One, I doubt that plastic treaties is the fastest way to stop ocean plastic pollution. The river pollution here in Asia will not change since the legal framework have been in place for years, but no legal enforcement is happening. What tools do you see to push for better enforcement in Asian countries through the influence of European and international entities? This is from Nick. I don't know, Michelle or Rogier. It's a.
I'm certainly not an expert in European entities in that context, so I might defer.
Yeah, the same is same for me. But I thought that there were some new rules, EU rules upcoming, that also companies could be held here liable, for example, if they neglect human rights in the world somewhere, also outside of the European Union. But
what I could add from our experience is that the power of the public and the power of media. So regardless the available framework, whether it's Asia or North America or Europe, regardless the framework, what can help and what advice we got from others is that talk about it, show it, expose it, take action, even within your small local community, even using the power of social media or taking a local journalist with you who would publish it. So expose it. And with that, you can kind of force your elected politicians or authorities to take action. So when the law fails, then the power of public stays.
And this is something that came out a lot also during the Our Ocean conference in multiple occasions on the side event. One last question. Thank you. Was looking at public-private collaboration in enforcement, but also solution that incorporates forms of nature responsibility in decision making, or statute-based or by convention on the part of insurers, business owner, etc. Wait, I have to. Do you see the questions? Otherwise, I will reread it. I was looking.
I'm just not sure the question, or maybe it's a comment instead.
Yeah, could be.
I don't see it.
Yeah, I think it sounds like a comment, but let us know if I'm missing something. There is another one. How would you create a legal representation for the ocean? It seems to be far more complicated than in the case of a river. For example, what if one country does not recognize or sign the treaty or agreement for ocean rights? This is for Michelle.
Yeah, I mean, we are seeing at the national level, like I said, national law is recognizing rights of nature as a whole, and that includes marine ecosystems. So, for example, in Ecuador doing so, that includes their exclusive economic zones, their 200 nautical miles that they have jurisdiction over, has rights within the territory. And they've been able to enforce that, for example, for illegal fishing in the Galapagos Marine Reserve, illegal shark fishing, they used rights of nature within that court case to hold the crew and the vessel accountable for damages done. But certainly that's why we need, when you think about the fact that we have one ocean and that damage transcends those imaginary lines and boundaries we draw on a map. That's why we need to look at international law and what we can do under international law. And that's why the initiative for a Universal Declaration of Ocean Rights or similar has emerged to look at how we can put this in practice. And of course, that would require consensus. Ultimately, if you're looking at the UN system, but there are other ways that you can begin to look at creating, an international norm, whether it's going through UNEP, the IUCN, you can start to take steps towards socializing the concept, which is what we're doing right now. So it's not something that will happen overnight. We have still an audacious goal of achieving this by 2030. And so giving us some time on that, but even that, as we know, might be very, very audacious.
Yes, agree. So we are almost closing. If you allow me one last question, there's this one. Do you think the IT law's decision on state obligation to protect the ocean will hinder companies from polluting? I think, Michelle, did you mention before?
Can you repeat that question?
Do you think the ITLO's decision on state obligation to protect the ocean will hinder companies from polluting?
I don't know what decision that's referring to.
Okay, that was my question, because I think somebody mentioned it before, but I'm wrong, maybe. See if you can write in the chat. Daniela. Let me see if in the chat there is something. Oh, I see. Meanwhile, other questions.
It lost. Oh, okay. Sorry. I couldn't put that together.
Okay.
Well, yes, we're seeing that private companies also have responsibilities under international law to respect human rights and the obligation to protect and preserve the marine environment. So I do think it will not just be applicable to states, but also private companies. Sorry, thank you.
And it will stop, from polluting. Okay. And there is a last question on the chat. Taking into account the lack of resources for developing Conservation Act, what are the thoughts about using environmental insurance capital for this reason? Involve a private insurance company. This is something that also Veronika touched on the ghost farms, on insurance based.
Yes, I love the idea, and indeed we believe in public-private partnerships and investigating in what mechanisms would be the best to tackle this issue. I don't know if Rogier has anything to reflect on more than this.
I don't understand the question completely.
It was more a comment of saying that what kind of insurance mechanisms could work in the case of environmental insurance capital, for the reason to bring in money into the system when government money or insurance mechanism, government base, is not available in order to cover polluting companies.
I don't have a concrete answer, I'm sorry.
Okay, so I think we have, the time is out, we have to close, but please write us if you have other question. I see that we might have missed some, but thank you very much to the speakers and to all people who are in the webinar today. Hopefully this will give you some ideas or and we will share some follow-up resources also with you. The recording will be available. Thank you everybody for being here with us, and until next time, for all of us at LTCs, take care, and we see you soon. Thank you everybody.
Thank you.
Thank you.